Good afternoon, and thank you for joining us for the Commercial Real Estate Appraisal webinar. My name is Craig Burnham. I'm a marketing manager with Sageworks, and I'll be today's moderator. A few housekeeping matters before we begin. All attendees are in listen-only mode, so there's no need to worry about background noise. We welcome you to ask questions at any time throughout today's presentation by using the GoToWebinar control panel as illustrated on this slide. Also in the control panel, in the handout section, you can download PDFs of today's slides. A series of polls will be conducted during today's webinar, and we encourage you to participate by selecting an option on your screen when they appear. A recording of this webinar will be emailed to attendees after today's presentation. First, a little bit about Sageworks. Sageworks is a financial information company that provides credit and risk management software solutions to financial institutions, helping them grow profitably while mitigating risk. Our data and applications are used by thousands of financial institutions, corporations, and accounting firms across North America. Now, a little bit about Mountain Seed. Mountain Seed serves several hundred community, regional, national, and international banks with their appraisal management and appraisal review functions. Over the years, Mountain Seed has developed a specialty and industry reputation of expertise in the commercial appraisal process and has assisted hundreds of banks in all 50 states manage compliance, streamline appraisal ordering, and improve appraisal review quality. And finally, a little bit about today's presenters. Nathan Brown develops and executes the company vision and goals at Mountain Seed. He leads the core teams of sales, operations, technology, government relations, compliance functions, as well as the research and execution of the new products and services. Prior to Mountain Seed, Nathan practiced law with Seyfarth Shaw LLP. While working at the law firm, he worked with Mountain Seed to develop structure and compliance around new emerging regulations. Terry Bowditch has been in the appraisal business since 1984 at Mountain Seed. Terry manages a team of senior review appraisers and oversees Mountain Seed's appraisal policy, review standards, and forms. Additionally, Terry has advised many lenders in regulatory exams and worked directly with appraisal experts at several financial regulatory institutions. Very briefly, this is a legal disclaimer that we're obligated to share, and feel free to read through it on your handout. And I'd now like to pass it over to Nathan and Terry to kick things off.
Thanks, Craig. Thanks for having us here. We're looking forward to this webinar. We do have a packed agenda. As you can see, we've got 8 topics to cover in somewhere around 40 minutes. Each of these could probably be a webinar unto itself, so we've only got about 5 minutes to touch briefly on each of these topics. I'd suggest, and I think we'd suggest, that you use this webinar as a kind of checklist. We really don't have time to develop a lot of background on each of these points, but really for issue spotting to make sure that your appraisal process is as tight as it can be. This is not to be confused with Craig's mentioning of submitting questions live for the webinar, which we're taking at the end. But after the webinar, if you need additional information from us on any of the substantive issues that we've talked about, we always leave webinar questions at mountainseed.com, webinar questions at mountainseed.com open, because we realize this is going to be very high level, and if you'd like more detail or to drill down with us on any of this, we'd be happy to do that. Similarly, the slides are going to be very high level. Bullet points, we're going to talk behind them. If you have more information or if you have questions and want more information, we'd be happy to talk to you after the webinar. Terry and I are going to go back and forth a little bit. That just kind of breaks things up, stops you from having to listen to my voice. Another housekeeping item, which I think Craig mentioned, there's going to be poll questions, and I think we're going to start with a poll question here in a second. Give us a second, be a little patient with us as those pop up. We are going to have to generalize some. Craig's already put a disclaimer up there. Obviously, we're not trying to give you specific legal advice. We've got to generalize about topics that may come from a 1,000-page rule. So just recognize that we're being high level and not trying to be completely comprehensive. Last point on how we came up with the content. So instead of our just sitting around and trying to figure out what we thought you might care about, we took the last 5 to 10 conversations that we have had with chief credit officers or senior credit personnel at our clients, and we used those to really come up with this webinar. So these are really expanded topics on things that we know are on the mind of bankers. And as the last point, our perspective on this, Craig mentioned it, 70% of our business is commercial. All of our clients are community or regional or national banks. And 30% of what we do is residential, but it's almost all portfolio lending. So the perspective that we bring is very similar to that of a community or regional bank, not like a lot of other of our fellow AMCs out there that may be focused solely on residential, high volume, secondary mortgage market stuff. So with that, I think we're going to launch our first poll question.
Okay, so we've got our first poll question here. How are you currently managing your real estate appraisal ordering and review process? This just gives us some background about who we've got on the webinar today, and it'll help Nathan and Terry kind of guide the discussion. So I'll give you just a second to go ahead and enter your responses in there. Okay, we've got just about 60 to 70% voted here. I'll give you one more second to get in your vote, and then we'll share the poll with everyone. Okay, it looks like 60% overwhelming majority have an internal department that orders and reviews, but they have no appraiser on staff. Followed fairly closely by internal department that orders, but they outsource the appraisal review. And we've got 12% outsourced ordering and reviewing of appraisals, and 8% has an internal department that orders and reviews with an appraiser on staff. So I'll go ahead and close that poll out, and I'll let Nathan take it away.
Great, that's helpful background. Thanks for that, Craig, for setting that up. So we're going to try to be relevant to everybody, to all categories out there, and really give you, as you're thinking about how your department is structured, try to give you the questions that we would be asking as you think about either your existing process or consider a change to your process. And the first question is to really be careful about considering who is loan production staff. So obviously your frontline loan originators, people who are out in the field drumming up business, or loan production staff. But if you dig into the regulations, you'll find that it's actually two categories: personnel responsible for generating loans, and then also people responsible for approving loans. And we've had clients, relatively senior credit people at our clients, actually give up their loan committee approval authority over this issue so that there was no question that they are independent from loan production staff. Obviously, everybody on the call, and we've got to presuppose some knowledge on some of these issues to get through it, but everybody on the call will recognize that for regulatory purposes, you need to be separating everybody who is loan production staff from your appraisal process, which means ordering, reviewing appraisals, managing and selecting appraisers. The second piece we've got in here, check their comp. The regulators really, since the most recent credit crisis, have been focused on how people get paid. Everybody knows that the regulators were focused on that for loan officer compensation. It's no different here. So there is this additional piece of not just what is their actual day-to-day job function, but also how they get paid. So you need to look at anybody who's got a bonus plan, a compensation plan, a commission plan that's based on how many loans get processed or approved, or whether certain loans get processed or approved. That person is going to be considered loan production staff for purposes of the test. What the regulators have said is okay is a general profit sharing plan. So if your bank has a general profit sharing plan that impacts everybody in the bank equally, that obviously doesn't make everybody in the bank loan production staff. So then we move on to reporting lines. So we've got in here a slide taken from, and you can see at the top there, one other note, we've got a listing at the end that I think Craig and SageWorks have dropped in of some of the references to some of the material we'll be showing you. But this is an article that was written in FDIC Supervisory Insights, not regulation itself, but authored by field agents, and it shows you in typical regulator style, really both the ends of a broad spectrum. So on the one side, we've got this concept that if your valuation review staff, anybody who orders, manages appraisals, or reviews appraisals, reports to the head of a loan department, and that person also has residential and commercial loan officers reporting to them, this is essentially the fact pattern in a D&O case that came out of the recent credit crisis. And that fact pattern basically said they had one appraisal reviewer inside the bank. I can't remember what her title was, something like head of underwriting. She was reviewing the appraisals and the environmentals for the bank. She reported to the head of the loan department. That person's compensation, I think he got a 1/4 basis point, or a quarter point, not a quarter basis point, a quarter point on all loans that closed. The allegation when the FDIC ultimately ended up suing the directors and officers was that her boss essentially could have caused her not to conduct appraisal reviews in the manner that she should have. So the structure on the left we know is insufficient. The structure on the right is what the FDIC came out with as quote-unquote optimized, and this is where you have essentially your entire valuation review staff reporting directly into your board or a committee. I don't know of certainly many banks or really any that we run into on a day-to-day basis that actually have their appraisal department reporting to the board. More likely that's going to run through credit or risk. Just know that there is a test up and down that the regulator very well could look up and look down through the reporting structure in determining who might be loan production staff. All right, so we get this question a lot, particularly on the reporting lines piece of this, and that is, but we're a small bank. So surely you can't be telling me that we, a small bank, are subject to this kind of reporting line separation. That may be true. So the regulators have come out and said for smaller rural institutions there may be some break here as long as you have safeguards in place. What comes up, though, more practically is it really is only the smallest institutions, and here we're talking about 50, 75 million in total assets, that I think can breathe easy with actually having loan officers involved in the process. So what we see is, at a very, very small or rural institution, you may have one loan officer reviewing the appraisal for another loan officer. That really, in our minds, is a 50, 75, maybe $100 million bank structure. In terms of where the break point is to have strict reporting line separations, we would suggest it's around 250 million. There isn't anything in the portfolio regulations that points to that number, but we borrowed it from consumer legislation. So in the Truth in Lending Act context, for example, the Truth in Lending Act on consumer deals is going to require pure separation of the reporting line compliance at 250 million in total assets. So generally speaking, our recommendation always is if you're near, at, or certainly if you're above 250 million in total assets, you need to be thinking about separating out your reporting line structures. Last piece of this is reviewer competency, and again, we could probably talk for 20 or 30 minutes on reviewer competency. Just know that the regulation since 2010, and there was some suggestion even before that in the earlier regulations that came out of the savings and loan crisis, but the regulation specified that the person performing the appraisal review has to have the appropriate education, competency, and experience, not just generally with real estate, but specific to the property type, and that certainly applies in commercial and certainly with more complex commercial loans. We'll talk later about regulation and the new changes to FIREA requiring that you review for use type compliance, but then obviously also substantive compliance. I know Terry in a little bit is going to go over some of the common deficiencies that we see and that our clients see in appraisals, but just be focused on that. The same D&O litigation that we referenced, part of that allegation, a major part of the allegation, was the internal bank employee performing the appraisal reviews was not trained as an appraiser, did not have in the regulator's view the appropriate level of education and experience to be performing appraisal reviews. Across the board, last point on that, across the board in terms of finding a pool of people who are qualified, it's difficult to look out and find a pool of professionals qualified to do these other than appraisers. I do want to be clear that there isn't a requirement that the person performing your appraisal review is actually an appraiser. And in fact, that was posed in conference committee when Dodd-Frank was coming into existence, and it was ultimately struck from conference committee. But although it was posed and struck from conference committee, you're still left with this problem of understanding use type, understanding the technical features of an appraisal. Certainly there are experienced real estate professionals inside of banks who can do it, but in terms of systematically finding a group of people to perform these reviews, it's difficult to find that, excuse me, outside of appraisers. All right, with that, We'll move on to the next slide, and this is where I get to pass it off to Terry. I'll just note that we could have picked 100 of these. I know when Terry and I were talking about this, he went to his senior reviewers and our appraisal reviewers and talked to several folks who suggested more academic topics. We could talk about substantive issues impacting the valuation of real estate, and certainly some of these can be substantive. But for purposes of providing you some sound bites, these are certainly a greatest hits list of some of the simple, not necessarily easy, but some of the simple to explain issues that we see on a daily basis and that we know our clients see on a daily basis. So with that, I'll pass it over to Terry.
Thanks, Nathan. Good afternoon, everybody, and welcome. First up is math errors in discounted cash flow analysis. They do occur fairly frequently, particularly in spreadsheets and appraisals that do not use Argus software or other similar commercial software for a DCF. We do check for math. We use the appraiser's assumptions, and then we try to confirm or replicate the DCF results that are in the appraisal. For some clients, we actually include our own DCF spreadsheet right with the review, so the client has an understanding that we have confirmed all the math. As is value. This is an important topic because every appraisal with very, very few exceptions needs an as is value. And just for a setup, the definition is a market value of real property in its current physical condition, use, and zoning as of the appraisal's effective date. And again, that's always required with very, very few exceptions. We've confirmed this with multiple regulators, including the OCC and FRB. We've even been challenged by an appraiser that took it all the way to a state appraisal board in a situation where, in a repair situation, they did an as repair value only. Even though the bank asked for an as-is value, the property was being sold as is, and the lender was loaning on an as-is basis. The appraiser insisted that that was not necessary and that the as-repair value was the proper value. He took that all the way through a state board and lost, and we were affirmed by the board that yes, the as-is value was needed. Also, it's noteworthy that particularly on the residential side, we find that appraisers try to resist this by saying that we're asking them, or the bank's asking them, or the regulations are asking them to do a second appraisal where they'd have to go out and find comparables and do a whole separate new appraisal. That's not correct, and in most cases, doing it that way would actually be an improper way of valuing the as-is value. It's in many cases it's fairly simple. In a situation for a renovation and repair, it's simply usually a cost to cure, whereby the appraiser would do the as complete value and then subtract out the renovation cost or the cost of repair. In a new construction, it's usually the value of the site or the value of the vacant land. In both cases, if the appraiser is doing their proper job, for example, with new construction, they should be valuing the land or the site and supporting that value. So they've actually done that part of the work, and it's just a matter of reporting it. Next topic is lease fee and fee simple. And a couple of things to note, because this one part of this ties into the as-is value. If a property is encumbered by a long-term lease, the proper as-is value is the lease fee. Sometimes the bank will ask for a fee simple if the appraiser only presents the fee simple and the property is encumbered by a lease. He or she is not provided an as-is value because the as-is value would be the lease fee. It's perfectly acceptable to provide both values, so the lease fee would be the proper valuation because it's encumbered by a lease, and then the appraiser would simply do a second value under a hypothetical condition in order to produce the fee simple value. The other thing of note under lease fee is when a property is encumbered by a non-market lease. Number one, the appraisal must clearly state the ownership interest, and if the contract rent is less than the market rent, which typically means that the lease fee value would be less than the fee simple value, then for loaning purposes, the bank must use the lease fee, i.e. the lower value. Next up is the extraordinary assumptions and hypothetical conditions, and these are similar, so I'm going to sort of treat them as one topic. And just as a lead-in, give you brief definitions and then wrap up with an example of the two. Extraordinary assumptions is an assumption which, if found to be false, could alter the appraiser's opinions or conclusions. A hypothetical condition is a condition directly related to a specific assignment which is contrary to what is known by the appraiser to exist, but is used for the purpose of analysis. So one thing to do is that you want to always be aware of their use and understand their potential effect on the appraisal. The other important point is, are they reasonable? Sometimes an appraiser will use an extraordinary assumption or hypothetical condition to obviate something which he should be doing because either the person's lazy or they don't understand how to do it. So you always want to question, are they reasonable? Because it could have a major impact on value. An assumption or condition about, say, the presence of asbestos, just by saying, oh, I'm going to assume there's nothing there, whereby the abatement of asbestos could cost more than, say, the building is worth. Same with just assuming the demolition of existing improvements has occurred. For example, again, the demolition cost could exceed the value of the property. And lastly, pulled from a real-life review that we did of a downtown office building, which by zoning required so many parking spots for it. The property did not have parking, and the owner was using nearby parking without a lease, and the appraiser just simply assumed that the property had the parking going forward, and yet there was no basis that there would ever be parking for that property, and that could have potentially a major impact on that property. And then lastly, most people understand new construction, and just to give you a quick example, the difference between a hypothetical condition and extraordinary assumption is on new construction. So if the appraiser uses a current date, they would use a hypothetical condition because the improvements don't actually exist. If an appraiser uses a prospective date, one in the future, he would use an extraordinary assumption because logically he presumes that those improvements will be there in the future. So I think that covers it, Nathan. Back to you.
Great. Thanks, Terry. So just one point that jumped into my head as Terry was talking, for those of you managing this process internally, a couple of thoughts. If you are not an appraiser managing this, a couple of resources for you. I know when we were considering what issues to throw up on this slide, I think somewhere around 60 or 70% of Terry's staff is an MAI, and we have a close relationship with the Appraisal Institute. There is an Appraisal Institute document of common deficiencies. It can get relatively heady and technical, but that's a decent resource that if you can't find, we can dig up and send that to you. The other thing that pops into my head is I think it's important as you're doing these reviews to think about using the results of your review process to then feed back to your panel management process. So obviously at the end of the day, the best way to ensure that you're getting good appraisals is to use good appraisers. And obviously, anybody would recognize that short of completely redoing the appraisal, it's difficult to catch every issue in any degree of appraisal review. So it's important that you're using these issues in your review process to feed back whether you're quality scoring or however you're managing your appraiser panel. Make sure it's on the basis of the reviews that you're performing. All right. Next big topic, and this has been something that I think we've had several clients come to us recently, all abuzz about HVCRE and specifically how that impacts the appraisal process. So I know I was laughing with Craig and the SageWorks guys earlier. You certainly don't want me telling you how to risk grade. You can go to Craig and SageWorks for that. But I will tell you that as far as how HVCRE links up or interacts with the appraisal process, it's worth just mentioning a couple things for everybody's benefit. And here we're really going to have to generalize. I would assume that most people on the call are familiar with HVCRE. It's a category of ADC loans created by the final regulatory capital rule. It bears a 150% risk rating penalty. And a key function of it is that even if it's an ADC loan, and by the way, 1 to 4 family, generally speaking, excluded here, even if it's an ADC loan, a commercial ADC loan, it's not counted as HVCRE if the borrower has contributed 15% prior to the bank funding the loan, and there's a contractual requirement to hold that 15% in the project. So if you satisfy those contribution requirements, generally speaking, it's not HVCRE, but coming into the deal, you don't know whether that 15% is going to be satisfied. So really on the front end, as you're ordering your appraisal, we're talking about, generally speaking, your commercial ADC loans. And the question that comes up is, what do I have to do if I know this is HVCRE? What additional steps do I take? There are webinars out there, there are review firms out there that I think would more or less suggest to you that there is special treatment of HVCRE for purposes of appraisal, meaning you need an additional appraisal review scope. You need to make sure that the appraiser doing it is specially qualified. I don't disagree with that. I would just argue that it's not new. So the final regulatory capital rule itself only uses the word appraisal a handful of times, and really just to mention as complete value, which we'll talk about in a second. But it's not new, and it's not based on the regulatory capital rule. What happens is, since 2010, the new guidelines that came out on the appraisal process, the regulators have said you should use a risk-focused or a risk-adjusted determination of your appraisal review scope. So in the old world, for anybody who remembers after the savings and loan crisis, in the banking world, for the most part, there was a compliance review and there was a technical review. You did a compliance review if it was a simple property. You did a technical review if it was a complex property. That really got replaced in 2010 with this idea of risk adjustment. For us, for most of our clients, even if you're handling this internally, I would actually suggest that the best way to think about it is to have one review form and one review scope that covers 95% of your commercial, certainly a different review scope that covers your residential, and then think about having something more. For us, we call it a full narrative product, and feels very different. For if you're outsourcing through us, it's more expensive, takes a lot more time, but have something that is dedicated to your highest risk properties. So the question that really comes up is, under this structure that is 2010 guidance based, not HVCRE based, what do I do with all my commercial ADC loans? That's a decision for you to make internally. Just recognize that the regulator has said, hey, we view these as particularly risky, thus the 150% risk weighting penalty. So certainly there's some fodder there for your regulator to take the position that they are particularly worthy of a complex or a comprehensive appraisal review. All right, so last piece about this while we're on HVCRE is the determination of whether the borrower has contributed 15% needs to be made on the as complete value. We've got a slide here in a second. So when you're doing the 15%, it's 15% of what? It's 15% of the as complete value as stated in the appraisal. So up front, the recommendation is make sure that anything that's commercial ADC, you're ordering the as complete value, not just the as stabilized value. And with that, I'll let Terry kind of fill in the gaps on what the difference is there.
Right. Nathan. All right, thanks. Fairly straightforward. The as complete value is when the property is physically complete. That is when the construction is done. The as stabilized value is when the property reaches its tenant occupancy to its projected stabilized occupancy. For example, 90% occupied. So what that means, the property isn't stabilized until it goes from zero occupancy once it's been completed to that 90% occupancy. And the dates could be significantly different. For example, it might only take 6 months for the construction, but it might take a year and a half to get up to that 90% occupancy. All right, back to you, Nathan.
Great, thanks. All right, so we're marching on here, and we're to this concept of how do I disclose to a borrower on the closing statement the AMC or appraisal fee. What issues are there? So most people on the call will know that we are now in the residential world. We're in TRID. TRID is a 1,000-page rule. We've got 5 minutes to cover a 1,000-page rule, so just know that we won't really do this justice. We actually recently did a joint webinar with a couple of experts over at Alston & Bird, our National Regulatory Council, including Colgate Selden, who participated in drafting this rule and the formation of the CFPB. So I'll give you a couple of highlights as they specifically involve the appraisal process, and this is probably one of those areas where that webinar questions at mountainseed.com, we'd love to help you get answers to anything you're searching for here. A couple of high-level thoughts as you're going through your mental checklist of your own internal process. On timing, we're really, for appraisal fee and AMC fee purposes, it's really this requirement that you get the initial loan estimate, what replaced the good faith estimate. That initial loan estimate's got to get out the door 3 business days after the application and at least 7 business days before consummation. That combined with the fact that now appraisal and AMC fees are both zero variance or zero tolerance, that creates a little bit of a problem, particularly if you've got an appraisal panel with appraisers at different fees, because you know, hey, I've got to make a choice about what I put on this loan estimate. A couple of things to note, and you know, these aren't necessarily on my authority, but on the authority of some of the real experts, which we'd be happy to put you in touch with. Zero variance or zero tolerance for this purpose means it can't go up between the initial loan estimate and the closing disclosure. It can go down. So what do we recommend that our clients do? We recommend that our clients take a look at their current fees for all of their appraisers and what form types they're using on the residential side, and get a tight range. You know, obviously you can throw out any extreme outliers, although just keep in mind customary and reasonable fee is out there under TILA, and we'll mention that in a little bit. But you know, keep that tight range, go to the top of that range, put that on your loan estimate, and then you can always take it down from there. Change circumstances always comes up, even under TRID. There is the provision for you to change that fee when new information comes up since you are preparing the loan estimate, or changed information comes about when you're preparing the loan estimate. There's all kinds of flavors of this, and when we were doing our other webinar, we went through a whole bunch of hypotheticals, and you know, we don't have time to go through all that, but all of you probably have experienced situations where the appraiser gets out to the property, they think it's a residential property and it's operating as a funeral home, or there's a 4-story barn, or it's on 30 acres. I mean, we could go on and on and on, and there's all kinds of cuts that you need to make on whether that's a changed circumstance. Happy to go through any of those specifically that you have. The other thing that comes up is reporting. For those of you, and I know it seemed like a relative few, but for those of you who are working with an AMC on the residential side, how you report the AMC fee with the appraiser fee. So just know, again, on authority much higher than me, that you can report those fees separately, or you can report them together. And one step further, you can report them separately or you can report them together, regardless of whether they were invoiced separately or invoiced together. So we at Mountain Seed invoice our fees separately from the appraiser's fee, and our bank clients actually continue to pay the appraiser's fee. That's a relatively unique model, and we don't have time to explain why we do that. For those of you working with a traditional AMC, you may be paying one fee that includes both the appraiser and AMC fee. Just know that you have a choice as to whether to pass them through together or separate. We've got this reminder out here about customary and reasonable fees. Not new. It's been around for 3 or 4 years. Just know it impacts banks. It impacts AMCs. It impacts a lot of people who touch the loan process. But there is a rule out there that requires you to pay at least customary and reasonable fees for the geographic market to your appraiser. So just keep in mind that there's a tension between wanting to know exactly flat fees on your appraisal side for purposes of being able to do your loan estimate, and then also making sure that you're giving appraisers appropriate flexibility under the safe harbors in TILA for customary and reasonable fee on complex properties, allowing the market to work, unless, of course, you're taking the safe harbor where you're referencing third-party government studies. There's very few of those. The Virginia Appraisal Board has recently adopted the VA appraiser fee card. So there's not many people out there using that on a practical basis because most people know that the VA fee card typically higher than what I would consider to be market, maybe not much. In some markets it depends, but you can always go to the VA fee card, use that for all your appraisers. My guess is that they would be happy about that. Or you can take the approach that we're suggesting where you're taking a look at your fees and just being thoughtful about who's on your panel. And this is just like so many issues that we deal with. It comes back to managing your appraiser panel. And the other thing, it's not on our slide deck, we've talked to $100 billion banks in this position. We've talked to $50 million banks in this position. Recently, across the board, there's been a lot of focus and emphasis on making sure you've got the right number of appraisers for your geographic footprint, making sure that those appraisers are qualified and competent to do the work that they're doing. We've seen a lot of banks with bloated panels, randomly assigning appraisers, and you can just get into a lot of trouble that way, and it's a lot easier to do one fell swoop, manage your panel actively, use that review process to feed back into your appraisal management process. All right, we're getting towards the end here. Vendor management of appraisal management companies and review firms. So everybody on the call will know that vendor management of third parties is a big hot button issue for the regulators right now. And not only is there general third-party vendor management guidance here, but the appraisal specific guidance actually speaks to this. And we've got quotes and all the backup we can provide to you if you want it. But the first specific thing that comes up is if you are outsourcing or considering an outsourcing your appraisal review function in any substantive way, you should think about this reviewing the review concept. And I think all of us here probably wince a little bit because we know how that sounds. Hey, I'm going to pay you to review the appraisal, or I'm paying someone to review the appraisal. Why am I then going to review the review? And the first question we always get is, well, do I have to review every single one you do? Well, no. You don't have to do that. But I would be thinking about taking a meaningful sample. And when we say meaningful, we're not talking about 50% or 20%, but I'll give you some real-life examples about how some of our clients that we consider to be handling this really well. There's one $5 billion bank on the West Coast that we work with that has I think, come up with a great process. And what they do is they pick 7 to 10, so we handle all of their commercial appraisal reviews. They pick 7 to 10 of those. For the first year, they did this biannually, so they did 6 months reviews. Now they're on a schedule of doing it annually. They picked 7 to 10 of the complex appraisal reviews that we did, and then they found, I think in their case, it was a retired MAI appraiser, to take a look at our review and to take a look at the appraisal together and essentially produce an audit report that they ended up sending to their board of directors, because everybody will know that the appraisal regulations specifically implicate your board of directors to know what's going on with your appraisal process. And certainly in light of the D&O litigation, I think there's a lot of justification out there for making sure that your board is very comfortable with the person in the firm that's doing your work. So this reviewing the review, think about picking 7 to 10 in the commercial context, maybe a little bit more than that in the residential context. I would just encourage you to make sure that whoever is doing this is qualified and competent, and secondly, that they are looking at the appraisal and the review together. So if you just pick 5 or 6 reviews and look at them on their own without the benefit of the appraisal, inevitably you'll end up, raising typos. We mix these letters up, those kind of things, and not that any third-party reviewer is trying to make those kinds of mistakes. I would just argue that what you're really paying that firm to do is catch substantive issues in the appraisal and make sure that within their scope of work, they're as confident in the value as they can be, and to really judge whether you're getting the right level of service, you need to make sure that your audit process or your review of the review process is capturing both the appraisal and the review. All right, licensing requirements, 2 things to talk about here. The joint interagency work group that's worked on all of this appraisal legislation for banking purposes relatively recently came out with their final rule on working with AMCs. We've had a lot of questions about that. It doesn't really change anything for you, the bank. It doesn't really change anything for us. It's similar to after the savings and loan crisis when they were establishing appraiser certification requirements. They are establishing AMC registration requirements. We're subject to those. Most any third-party firm who's doing ordering or reviewing of appraisals would be subject to that. There are 39 states where those groups need a license. Certainly, if you're in one of those 39 states, you need to make sure they have a license. The trickier issue, even if you're doing this internally, is this issue of licensing for the person performing the review. We don't have time to really unpack all the details here. Just know that federal preemption comes up. So prior to Dodd-Frank, certainly some strong arguments that particularly federally savings associations and national banks had special federal preemption that may protect them against state laws, and there are certainly states out there who have gone further and required both for appraisal reviews and for evaluations, and we really haven't touched on evaluations. We probably can't go very deeply into them. Just know that there are states that have gone further than the feds that have required special licensing that may implicate people performing evaluations or performing appraisal reviews that you need to be aware of, certainly if you are contracting with a vendor. So I'm not suggesting yet that state appraisal boards really have the political capital to go after internal bank employees over these laws, although I do know that we have heard from large bank chief appraisers coming out of the RMA roundtable that have been somewhat concerned about this, particularly in certain states. But just know if you are contracting with a vendor, think about this licensing issue as it applies to people performing appraisal reviews and also evaluations. Contracts, guarantees, and indemnities. This will be pretty quick. Generally speaking, if you're working with a third party on something as vital as your appraisal process, you need to make sure that you have a written contract. Both the appraisal regulations and the vendor regulations would suggest you need to understand from that contract and any supplemental materials and policies, not just that they are complying with your banking regulations, but specifically how. So, you want to make sure that someone can explain to you how their appraisal review, selection process, scoring, how does that fit in with my regulations and my regulatory requirements, because they are broad. Not only are they in for portfolio purposes in the guidelines, they also spread into the consumer world, into TILA, customary and reasonable fees. There's the ACOA stuff that we'll talk about, providing copies of appraisals to borrowers. We could go on and on there, but just keep in mind that there's a lot of complex legislation out there, and you need to have some comfort level that the person you're working with can navigate those. Also, keep in mind that specifically there's no safety in indemnities, so just because your vendor's contract says that they promise, guarantee, indemnify you for regulatory compliance issues, that doesn't let you off the hook for purposes of understanding how it is that they're going to be complying. Last piece, and this may change as you move up through the spectrum of total assets and size, whether you think about any vendor you're working with as a firm or whether you think about them as a collection of reviewers, however you think about them, the specific requirement that you need to keep in your mind is this competency, experience, education of the person performing the appraisal review. So you need to understand when you're engaging a firm to do your reviews or ordering or management, but specifically your reviews, who are the people who are going to be doing these reviews? What are their credentials? Particularly on the commercial side, watch out for groups out there who may be doing a great job on the Fannie and Freddie secondary mortgage market side who are trying to expand into commercial, who may have one commercial reviewer or using residential reviewers to perform commercial reviews. I won't ask Terry, but I can tell you his thoughts after 20 or 30 years of being a commercial appraiser and serving on state appraisal boards. I know we've seen residential appraisers in over their head on complicated commercial deals, and you don't want someone like that minding the shop on your commercial appraisals. All right, I think we got a poll question.
Okay, so we've got our second poll question here. When is the last time you updated your appraisal policy and review forms? We've got this year, in the past 2 years, over 2 years ago, or does not apply. Go ahead, we'll keep it open for just a second here and go ahead and let you answer. Again, just trying to get a feel for who we have in the audience. Looks like most people have put in their answer, so we'll be open for just a few more seconds and I'll share it with everybody. Okay, I'm going to share it. Okay, it looks like, we're very close here. So we've got 39% at this year, 39% in the past 2 years, 16% over 2 years ago, and doesn't apply to 5% of the audience. So Nathan, I'll give it back to you.
Great. So just one quick point on this one. There was a report, and we get questions all the time from people along these lines. There was a report that went to Congress and the OIG in 2013. It was very critical of examiners internally to the regulators for documentation over exam issues. One of the things that came up was this whole explanation of how regulators ought to handle appraisal-related issues inside of exams. The long story short, there can and should probably be a team looking at your policy and then a team looking at your loan files. The team looking at your policy may talk to the team looking at your loan files and say, hey, we found a weakness in your policy, we found a weakness in the forms, take a look through the files and see if the actual appraisals reflect that, and then vice versa. So just keep in mind that it is an issue, both what your policy says and what your review forms say. I don't think we have time, I wish we could, but to let Terry talk about his ongoing supervision of our forms and how often he's jumping in to revise those for things like USPAP changes, regulatory changes, clarity. So just if you haven't updated your form in a couple of years, know that it likely is outdated. Certainly if you haven't updated it in the last 4 or 5 years, know it's outdated, and that's something you need to be thinking about, is those forms need to constantly be changing, your policies need to constantly be changing. All right, we are running short on time, so we're going to do a sprint through these last few. Probably not do them justice. I will just mention again the webinar questions at Mountain Seed and also the references that Craig's got at the end of this slide deck can be helpful here. When you are providing copies of appraisals to borrowers, the issue is ECOA, Equal Credit Opportunity Act. It's a relatively new rule. Although the concept isn't new, the rule just amended an existing rule. When it applies, we're in the residential context generally, except recognize that this ECOA rule applies to dwellings. So whether the TILA stuff typically applies to consumer purpose loans, this ECOA valuation rule applies to dwellings, 1 to 4 family dwellings, even if they're business purpose. The timing here, you have to provide a copy of the appraisal or the valuation promptly. At least 3 business days prior to closing, and then the kicker, whether or not it closes. So even if the loan doesn't close, if you've developed and relied on evaluation in that analysis, that credit analysis, you have to provide a copy of that to the borrower. What about evaluations? Yes, evaluations are included. Yes, even if that's done by an internal person at the bank, that evaluation needs to go to the borrower, and even if the loan doesn't close. What about reviews? No, if you have an appraisal review, you do not have to provide a copy to the borrower under this rule, so long as it does not develop an independent opinion of value. So if your review develops an independent opinion of value, all of you probably know the interagency guidelines do allow a reviewer appropriately qualified to develop an opinion of value in a review, and Terry would tell you that under USPAP, that's both an appraisal and a review. So for those of you looking for vendors to do that for you, recognize that they really ought to be charging at least as much as an appraisal to do that, because the appraiser is going to be required to develop the same work file. And I'll jump off my soapbox because I know we're running out of time. Just know that is a possibility, but if you're not doing that, if you're not developing an opinion of value in that review, you're okay not providing that. The last piece of this to think about is how do you provide the appraisal? So if you provide the appraisal electronically, that's permitted. You've just got to be careful of the e-sign act. So when we do this, we've got electronic software. We're providing an appraisal-specific e-sign consent disclosure for the borrower. Happy to talk in more detail about that with you. If you're generally speaking getting e-sign disclosures in connection with your loan process, you may be okay. Just know that the guidance is going to point you to making sure you comply with the e-sign act if you're electronically delivering. Otherwise, you may be manually delivering. All right, wrapping up here. Lending on another bank's appraisal, probably clearly in the top 1, 2, or 3 issues that we talk to banks about. So can you do it? Yes, you can lend on an appraisal addressed to another bank. Just know that you can't take it from your borrower's hands. I don't have time to really unpack that statement, but you cannot take it from the borrower. The most common situation is the borrower's gone to another large bank or a competitor around the corner. They've started their loan process. For whatever reason, it fell out with that bank, but they've spent $2,000 or $3,000 on a commercial appraisal. They come around the corner to you and they say, here's my appraisal. I've already spent $2,000 or $3,000 on it. Didn't go through with this other bank for whatever reason. I'd like to not spend another $2,000 or $3,000. Can you do the loan? You can, but just know that you've got to reach out, or the borrower's got to reach out to that previous financial institution and get them to send it to you directly. Know that other institutions, large and small, have policies here. You've got to make sure, fast forwarding to this last point, if you have or want to make changes to that appraisal, so, okay, we've done it, how do I make changes to this? If you've got to subject it to the same standard of review that you use on your ordered appraisals. You've also got to make sure that when you're reviewing it, you're doing something to confirm that was ordered independently, reviewing the engagement letter, and then recognize that if you just call that appraiser and say, hey, I'm, some such and such other bank, and I'd like to ask you a couple questions, or can you make these changes, that appraiser's confidentiality obligations run to the original bank, not to you. So you need to try to get a letter from the original financial institution giving that appraiser permission to talk to you instead of their original client. So we've got copies or forms of those letters, can help you understand what that might look like. I do want to quickly just pass it over to Terry to address this issue of readdressing or assigning appraisals, because it's very different than the way you handle, for example, phase 1s. So Terry, you want to speak quickly to that?
Sure, I'd be glad to. And just to sort of dovetail your comments, because the interagency guidelines require a couple other things. The appraiser must have been engaged directly by the bank, by another financial institution. Number 2, the financial institution ordered the appraisal, not the borrower, and an institution must not accept an appraisal that's been readdressed or altered by the appraiser with the intent to conceal the original client. And then it refers to USPAP, and under USPAP, an appraisal cannot, I've got to emphasize that, cannot be readdressed or simply transfer the report to another bank. The request is considered a new assignment and establishes a new appraiser-client relationship. So, all right, Nathan,
Great.
Back to you.
Thanks, Terry. All right, we're about running out of time. I know Craig wants to get some questions in at the end. Let me just say, what's next on the regulatory front? If you flip back and we can go one more slide forward, Section 1110 of FIREA is the section in the early 90s that birthed all of the appraisal regulation that you know and either love or hate. It originally provided 2 things: that real estate appraisals must be performed in accordance with USPAP, and 2, that each appraisal must be written. Obviously, the regulators took that and ran a lot further. Dodd-Frank amended that section to add a 3rd key pillar of appraisal regulation, and that is that appraisals be reviewed for compliance with USPAT. The regulators have yet to come out with the rule that's going to develop this so that you can actually comply with it. The 2010 guidelines clearly make it required to review appraisals prior to the final credit decision, but we are all waiting for the interagency work group to really flesh this out and to determine what it means. So that's what's next on our radar screen. And I think with that, I will turn it back over to Craig and to SageWorks. Thanks, everybody, for joining.
Great. Thanks, Nathan. We're going to get to some Q&A here in just a second. We've had several questions come in during the presentation. So if you do have questions, feel free to enter them in the sidebar and hang tight. We're going to get those answered for you in just a second. We'll even stay a few minutes after to continue to answer questions if we can. But first, we wanted to get some feedback from our audience. Obviously, we want to keep the focus on the appraisal process and making that easy, but SageWorks has a history of helping banks and credit unions manage their commercial real estate risk with software that imports tax returns, calculates global ratios, analyzes property income projections, stress tests commercial real estate. So if any of these areas are inefficient at your institution, we'd be happy to help. If you'd like to learn more, please go ahead and let us know. Go ahead and we'll keep that open for just a second and we'll move on to our Q&A. Okay, we've got most of the responses in here. I'll leave it open for just a second if you want to continue putting in your answer. Okay, we'll go ahead and close that out. And we also want to give you some time to learn more about Mountain Seed. They've been very generous with their time today and provided some really good content for everybody, and we really appreciate their time. So we want to give you an opportunity to learn more about them. Mountain Seed has helped hundreds of banks with their appraisal management and appraisal review functions. So if you're interested in learning more about Mountain Seed, please go ahead and just let us know now, and they'll reach out to you. Looks like we've got most of our responses in. I'll give it just a second to put in your answer. Okay, we'll go ahead and close that out. Thanks so much for participating. And real quick, we want to let you know, coming up this September in Austin is our 2016 Risk Management Summit. Join us for sessions on CECL, the ALLL, risk management best practices, led by experts from Crowe, Howarth, Grant Thornton, Clifton Larson Allen, and more. Early bird registration is available through May 31st, and register today to take advantage of the $300 savings. So we'll go ahead and jump into some Q&A. I know we've got some questions here. So Nathan, if you're ready, I've got the first question queued up for you.
Shoot.
So we've got a question here. Our bank is considering using our panel appraisers to perform appraisal reviews. Do you have any thoughts on this?
Yeah, great question. So we see some banks out in the industry, out in the world trying this. Two thoughts. One is a regulatory thought. One is a practical thought. The regulatory related thought is that the same edition, that article, the 2011 FDIC Supervisory Insights publication, has a sentence, which doesn't appear anywhere else in the regulations to my knowledge, has a sentence that says, using one appraiser who may bid on the same assignments to review another appraiser's work. So essentially, if you're in a market where you have several commercial appraisals local to you and they compete and bid for the same work, using one of them to review the other's appraiser's work may be a violation of independence, and we can send you that section. The other thing practically to keep in mind is, regardless of whether it's a regulatory violation, one thing that we see oftentimes and have heard specifically from banks is when you are in that situation, you may end up with impasses because your local appraiser who competes with the other local appraiser is reviewing his work. They may not get along, and or if they're competing with your work, one may be trying to show you that the other is not appropriately qualified and so forth. And we've heard stories of reaching an impasse over what ought to be an issue that you can work through, but simply because those two appraisers have difficulty working together.
Awesome. Thanks, Nathan. And we've got our next question that came in here that we've got flagged. So the question from the audience is, how old of an appraisal can you use for a final credit decision, either if the appraisal is prepared for the bank or another bank?
Yeah, great question. So this has been kicked around for a while. The only regulation that I know of that's out there is both in the secondary mortgage market context. There's some time periods. The NCUA, actually, funnily enough, for any credit unions, but the NCUA flirted for a while with a 6-month hard line, 6-month test, but essentially regulators have gone away from trying to look at a hard 3-month, 6-month, 9-month, and instead the question is the appraisal still valid? And I would suggest that anything over 6 months, you need to be thinking about validation. Validation is a tough thing under the guidelines because many of you may be familiar with the evaluation issue where you may be able to order an eval instead of an appraisal in a renewal context, and there's questions about new money, and there's questions about has there been an adverse impact on collateral. If you are trying to validate, you need to understand that the legislation requires you to prove out that essentially you've had no change, no up, no down, and I know of banks that have confirmed that with their regulator, that you need to be able to show that since the effective date of the appraisal, there's been essentially complete status quo in the market, complete status quo in terms of the physical condition of that property.
And Nathan, just a quick add-on, the interagency guidelines basically puts the burden back on the banker to determine that, whether or not the market's changed, whether or not the values change. So it really just it sort of reverses the question and puts it back on the bank to determine whether or not that appraisal is still valid.
Thanks, Terry.
Thanks, guys. So I think we have time for maybe one more question here. So another question, final question from the audience. My regulator hasn't asked about my appraisal process in a while. Are they about to start?
Great question. It's an anomaly. Here's why. We actually hear the opposite, and I'd love to tell you that I have the schedule of when the regulator is going to ask about the appraisal process in your next exam. We certainly see a wave of attention on this front. I mentioned this really briefly, but I think it's worth reiterating. In 2013, the OIG sent a report to Congress on the credit crisis. There is an entire section on the appraisal process. When a report goes to Congress that says that the examiners have fallen down on the job when it comes to their documentation of the appraisal process in exam teams, and in fact we've got this information if anybody's interested, but the report goes on to categorize and itemize the kinds of errors and the kinds of violations that examiners were citing in those exams. And when you have that go to Congress, what ends up happening, and I remember sitting at an RMA event across the table from a regulator who'd actually worked on the examination documentation module, the ED module that the regulators use in field examinations, and confirmed that, hey, there has been calls down from Washington to the field to say you need to be paying attention to the appraisal process. That's not breaking news. Obviously, that's 2013 I'm talking about. But we have just, you can use our sales efforts. I mean, we have talked to banks who said, we're doing everything just fine. We've got a local broker doing BPOs. That's sufficing for evals. We've got our lenders involved in the appraisal review process. We haven't heard boo from our regulator, and we've had those people call us back and say, I need help. I just got blown up on my exam. So want to be careful about scare tactics again. I can't promise you that your next exam is going to involve the appraisal process. Just know that a lot of your peers are certainly getting questions along those lines in their exam.
Awesome. Well, thanks so much, Nathan and Terry. I appreciate you staying a little after, and I appreciate everybody staying on the webinar until the very end there to get those questions answered. We still have several questions that got asked, we will make sure to follow up either with SageWorks or Mountain Seed, and we'll make sure to get you some answers to those questions. So there's several in there that we just don't have time for today, so we'll make sure to follow up with you very quickly and get you some answers to your questions, so be on the lookout for that. But that concludes today's webinar on commercial real estate appraisals. Again, thanks so much to Nathan and Terry at Mountain Seed for joining us, and on behalf of SageWorks, thanks for joining us.
Thanks, everybody.
Thanks.